Good morning. I'm just doing a quick little sound check and saying good morning to you both.
Hi, Michelle. You want to do one?
Yes, I heard you. Sorry about that.
Not a problem. Thanks so much.
think we're good.
Yeah, Tyler, can you hear Nick?
Yes, thank you.
Yes.
That word?
Thanks, Nick.
Good morning, everyone. Before I call our case, let me just check in with our court reporter.
Good morning, I'm ready.
All right, great. I'm now calling proceeding number 23A-0589EG. Today is May 13th, 2024. It is 9:00 a.m. This is a fully remote evidentiary hearing in the matter of the application of Public Service Company of Colorado for approval of its combined electric and natural gas demand side management and beneficial electrification plan for calendar years 2024 to 2026. We were scheduled for this hearing by decision number R23-0086-I. My name is Melody Mirbaba. I am the administrative law judge who was assigned to hear this case. Consistent with commission practice, we are webcasting this hearing. That includes the video and the audio, and we do have a court reporter taking down everything that's being said. So before we move to entries of appearance, I'll just advise that if at any time I mispronounce anyone's names or refer to somebody by an incorrect gender pronoun, I definitely do not mean any offense. So please just correct me, and I will endeavor to get it right moving forward. With that in mind, let's get started with entries of appearance. I'll just go down from my list here. Let's start with Public Service Company of Colorado, who I'll just refer to as Public Service moving forward.
Good morning. My name is Tyler Mansholt. I'm in-house legal counsel with Public Service Company of Colorado. And with me is co-counsel Ms. Shields, who I'll give the floor to now.
And good morning, Your Honor. I am Caitlin Shields with the law firm Wilkinson, Barker & Nauer, LLP, and joining me is my colleague Lauren Caliendo.
Good morning. C, for the Colorado Public Utilities Commission, Charles Staff, who I'll refer to as staff.
Good morning, Your Honor. This is Assistant Attorney General Ross Smith on behalf of staff. I'm joined by my co-counsel, Katie McLaughlin, Assistant Attorney General. Good to see everyone this morning.
Good morning, good to see you. On behalf of the Utility Consumer Advocate, who I will refer to as the UCA.
Good morning, Your Honor. Michelle Singer-Nelson appearing on behalf of the UCA from the AG's office.
All right. On behalf of the City of Boulder, who I'll refer to as Boulder. All right, we'll come back to Boulder. On behalf of Western Resources Advocate, who I will refer to as WRA.
Good morning, Your Honor and parties. Park Sproso for Western Resource Advocates.
Good morning. Okay, on behalf of the Natural Resources Defense Council and the Sierra Club, who I will collectively refer to as the Conservation Coalition.
Good morning, Your Honor. Matt Gerhart, and appearing with me is my colleague Jim Dennison.
Good morning. On behalf of the Southwest Energy Efficiency Projects, who I'll refer to as SWEEP.
Good morning, Your Honor. Robert Ragonin from Earth Justice, appearing on behalf of SWEEP. I'd also like to enter the appearance of my co-counsel, Michael Hyatt.
Thank you. Good morning. On behalf of the City and County of Denver, who I will refer to as Denver.
Good morning, Your Honor. Mandy MacDonald, Assistant City Attorney from the Denver City Attorney's Office. I'll also enter appearance for my co-counsel, Chuck Solomon. I don't believe he's on the hearing this morning. However, we may tag team throughout the week.
Okay. Good morning. And on behalf of the Colorado Energy Office, who I'll refer to as CEO.
Good morning, Your Honor. Jacqueline Colicchio on behalf of the Colorado Energy Office. Jackie's displayed on the screen. That's fine too. Thank you for having us.
Good morning. On behalf of Energy Outreach Colorado, who I'll refer to as EOC.
Good morning, Your Honor. Gabriella Stockmeyer of the law firm Dietz & Davis on behalf of Energy Outreach Colorado. My colleagues Daniel Rubin and Mark Detsky are also here today and will at times be participating on behalf of VOC.
All right, thank you. Good morning. On behalf of the Energy Efficiency Business Coalition, who I'll refer to as EEBC.
Good morning, Your Honor. Mark Detsky of the law firm Dietz and Davis, entering my appearance for EEBC. And also, as Ms. Stockmeyer said, Ms. Stockmeyer and Daniel Rubin are available for EEBC as well.
Okay. Good morning. On behalf of Clean Energy Economy for the region, who I'll refer to as CLEAR.
Good morning, Your Honor. Sarah Keene of the law firm Kaplan, Kirsch, and Rockwell, also entering the appearance of my colleague Riley Scott.
The sound was not that great, so I just want to repeat your name to make sure our court reporter caught it. Sarah Keene, correct?
That's correct. Is this any better? And I'll work on that.
A little bit better, but I don't think I caught anything more than your name. So do you want to reintroduce your co-counsel?
Thank you. Appreciate that. I'm also entering the appearance of my colleague Riley Scott.
All right, thank you and good morning. On behalf of Climax Molybdenum Company, who I'll refer to as Climax.
Morning, Your Honor. Richard Fanyo on behalf of Climax Molybdenum Company.
Good morning. On behalf of Colorado Energy Consumers, I'll refer to as CEC.
Good morning, Your Honor. Parties, Michelle King of the law firm Holland and Hart, here on behalf of the Colorado Energy Consumers, and I'd also like to enter the appearance of my colleague, John Sherry.
Thank you. Good morning. On behalf of Icon Energy, or I'm not even sure I'm saying that right, Icon Energy Limited.
Good morning, Your Honor. Mark Valentine from Keys and Fox, and I'm here on behalf of Iconergy.
Iconergy, thank you. I've been playing with that one for a while, and I just couldn't get it right. Good morning. All right. So I've got a couple of preliminary matters I want to talk about, and one of them is pretty big. So as I understand it, the parties here are also parties to public services pending clean heat plan proceeding, which is proceeding number 23A-0589EG. And if that's wrong, I'll let the company correct me as we move forward on this, but that's my understanding. So if that is correct, then I'm going to go ahead, and I would assume that if you are a party to that proceeding, you have been observing the commission's public deliberations in that proceeding, which have been ongoing, and I think most recently up until Friday, May 10th. And I understand that during that public comment hearing, the commission approved a pretty long list of guidance items that the commission wants the parties to develop. And that would be essentially to coordinate use of funding arriving out of that clean heat plan proceeding and the funding arising out of the strategic issues proceeding, which is proceeding number 22A-0309EG. As everyone at this point, I think, is aware, the commission approved a budget for the company's DSM and BE plan, DSM standing for demand side management and BE standing for beneficial electrification. That budget was, there was a budget for that approved in that strategic issues proceeding. So the way I see it, this guidance that the commission just recently issued is directly relevant to our case and many issues in our case, potentially. And while I understand the commission, has not written a written decision in that case yet, and the parties very well may take issue with some of the guidance that the commission issued on Friday through RRR motions, I do have a couple of questions about that guidance that I'm hoping the parties might be able to address before we get started to the evidentiary portion of our hearing. So, I mean, I'll list my 3 questions. If you all write these down, I'm going to try to run through and see if parties have positions on these questions. I also have notes on the very long list of guidance that the commission described during its deliberations on Friday, and I can certainly run through that. My list indicates there are 15 items. So I can run through that if that would be helpful, and I'll let you all let me know if you think that might be helpful for me to run through all 15 of those on the record here once you hear what my questions are. So, the first question is really, are the parties even aware of this list of guidance items that the commission just described on Friday during its deliberations meeting in the clean heat plan? Second, I really want to get a sense from the parties as to whether, and if yes, how those guidance items can be implemented and addressed in our case, particularly given the timing that we're dealing with here. And then third, if the parties had more time, do you have a sense for whether you could leverage the commission's guidance out of the clean heat proceeding to resolve any disputes in our case? So let me start by calling on the company.
Thank you, Your Honor. And thank you for raising these issues. We understand the importance of what's going on here and somewhat of a unique situation with another proceeding going on in a different litigation that could potentially have implications for this case. Maybe one of your first introductory questions was, are all the parties the same in both proceedings? I do not believe that's the case. I don't have a full matrix of the parties, but I don't believe Clear, for instance, was a party to the clean heat proceeding. I'm not certain whether EEBC was a party to the clean heat case, and there could be others. So parties aren't necessarily all in privity for that other proceeding, just as what I can recollect.
With that in mind, then do you think it makes sense for me to just spend a couple of minutes going through and just listing these 15 guidance items?
It could. I'm not sure if it changes the company's position on.
Let's hear your position first. Yeah.
Yeah. I think generally, the difficulty of this issue is that, as you've discussed, we don't have a written decision, and we certainly don't have a final written decision. So what requirements will really come out of that proceeding are just simply unknown to public service at this time. I think we can certainly agree there was a lot of good discussion on the clean heat proceeding and integration issues for this demand side management proceeding. But the company generally does not have enough certainty to change its positions at this time from what is proposed in this DSM case, given we don't have a written decision with clear requirements or directives, let alone a final decision in that case. So I think the company is willing to go through the list of items and have more discussion, but I think overall it'll be difficult for us to assume or speculate on what the final decision will be in that proceeding, and then how to precisely address it in this case until there's more guidance from the clean heat proceeding.
So do you have a sense then as to whether, we can do anything with that guidance in this case?
Well, I think that the company has put forth a proposal for clean heat integration. And this is in our first witness's testimony, particularly his rebuttal testimony. I think that there could be some questions and thoughts about how that proposal will work to facilitate some of these items addressed by the commission in its deliberations. I think our proposal remains the same, but that you could potentially think about our proposal in light of tangible examples being discussed in clean heat.
if there was more time, say, for, the commission to issue its written decision in that proceeding, would that change anything in terms of how the company would approach it here?
That certainly that is a possibility. If there was a written decision, we had clear guidance in the final decision, and we knew that there was a final decision approving changes to DSM in a different proceeding, we would have to think about how to make those changes in this case as well. And there are some flexibility items for DSM that Your Honor may or may not be aware of. The company can make changes to its programming outside of litigations. These 60-day notice processes is the phrase we use. So some of these issues may be resolved outside of the litigation as well. But generally, I do agree that if we had a written decision and that enough time to factor that into this case, there could be potential for some adjustments. That being said, the company has heard some concerns from parties in this current DSM proceeding about extending the proceeding, in particular, what that impact may have on changing our programs, getting new products in market. I think there's a general concern that parties might be able to raise on what the customer implications would be for an extension of this DSM plan, because that would effectively slow down a bit of our program changes at issue in this case. So unfortunately, there's not an easy answer, and I understand why Your Honor is wrestling with it. It's either wait and get more certainty that we can reflect, or move forward with the understanding that there could be more flexible ways of making adjustments through our compliance filing in the DSM case, or through a 60-day notice process. So sorry, I don't have a silver bullet answer, but it is a tricky issue.
Yes, it is. And I assume when you were talking about if this case is extended, I assume what you're referring to is if there's more of a delay than currently anticipated and when a final decision would come out. Is that what you're referring to?
I think what I was trying to articulate is that in this current DSM proceeding, the way the company implements final changes from the final decision is a compliance filing that occurs, I believe, 30 days after a final decision. And that compliance filing will include changes to programs, potentially, such as the company has proposed and parties have proposed. And so if we add more time to the statutory deadline for this current DSM proceeding, those changes would not necessarily be implemented by the company until there is more finality of this proceeding.
Right. So just an overall delay in implementing the plan is really what we're talking about.
That's correct.
And I understand. I get it. I get it. Nobody wants that delay. I will say my understanding is that the vast majority of proceedings like this have at least some sort of partial settlement where the parties are able to come together on a lot of, I would say, sort of the technical details of specific programs. And we just don't have that in this case. And so we've got a tremendous volume of issues that have to be addressed. And that is even just setting aside this now issue that we've got with this other pending case potentially impacting what happens here. And resolving those impacts through a 60-90 day notice process really may not work, because we're talking about, I mean, even just from this one thing they did on Friday, a list of 15 detailed items. And I just don't know that all of that is resolvable through a 60-90 day notice process. But I guess that just remains to be seen. So based on what you have said, it doesn't sound like, the parties will be able to say much more in terms of could you all come together and resolve disputes if you had more time. But I still want to hear from everybody before we move on from this issue. So let me turn to staff.
Thank you, Your Honor. Yeah, if you have anything you'd like to specifically ask staff, otherwise I think I have a couple of thoughts on the questions you've brought up.
Okay.
So I think first I just like to say I think staff was also frankly surprised that partial settlement was not possible in this proceeding. We think given the overlap of the positions of the parties, so we do share some of the surprise there. I think several of the parties would also recognize that. As far as the awareness of the guidance, so the items from the Clean Heat Plan discussion, obviously we're still, wrestling with the outcomes from that discussion. We don't have a written decision. At the same time, I think that some of the concerns, particularly the concerns regarding the Clean Heat Plan DSM incentive overlap and the order of the funding streams, those issues, staff does frankly share the concerns of advisory staff and the commission that were expressed on Friday. And as you know, I don't know if those issues are necessarily resolvable between us and the company at this point, but I think given that guidance, I would say that one of staff's primary issues in this proceeding is just that issue. So having a final decision from the commission on that would be, I think, very helpful to our position. As far as if we could resolve any issues to have more time, I think I would like to say yes, but again, given the settlement tenor here, I don't know that that's sort of a two-way street. So I think staff would be open to at least discussing that, but I don't know if that's possible.
All right, thank you. Since Ms. Keen has used the raise the hand feature, why don't you go ahead and I'll call on you next for clear.
Thank you, Your Honor. Is this audio better, first of all?
Yes.
Great, thank you, and apologies for that. I just wanted to offer, Casco Council is correct that we're one of the couple parties that is not involved in the Clean Heat Plan. That said, I am closely monitoring it on behalf of other clients, and so watch the deliberations on Friday. So if I'm the only one, there's no need to go through the list of 15 on Clear's behalf, and I just wanted to offer that. Thank you.
Okay, well, I mean, since you mention it, I'll just ask if there is a party who would like me to review those 15 items just to get them into the record, or for anybody who may not have listened in on the hearing on Friday, just go ahead and use the raise of hand feature. Ms. King. All right, so I think we've got at least two parties, Ms. King, Ms. Stockmeyer, have used the raise the hand feature. I'm happy to run through those. So why don't I just go ahead and do that? And that way, at the very least, we have it in the record. And I think we all agree this is what came out in a deliberation, commission's deliberation. It's public. It's not in writing in a commission decision yet. But I'll run through those, and then we'll pick back up going through, seeing what the parties might have to say on these issues that I've raised. So essentially what the commission decided was that parties, the commission wanted the parties to essentially use this list of guidance items to coordinate the use of funding from the Clean Heat Plan and the strategic issues proceeding, which of course ties into our proceeding, because the budget for DSM and BE was approved through the strategic issues proceeding. So those guidance items are to align DSM and BE offerings on incentives, eligible measures, customer eligibility, required forms, marketing, customer finance, and other program design elements, so there is minimum potential for confusion among customers, contractors, and other program participants, essentially such that DSM and BE program participants' experience are not different based on the source of funds or the proceedings in which the commission approved the funds. That's item number one. Item number two, to prioritize AC replacements with heat pumps is a cost-effective and efficient first step towards broader electrification. Item three, directly incent contractors to install BE and DSM measures. And the commission suggests that the parties consider contractor incentives at roughly 10 to 15% of customer levels. Item number 4, set and or modify in the future incentive levels for customers and contractors so that annual BE adoption levels at a minimum reach the yearly CEO roadmap values. Adoption levels of BE should be tracked and reported by at a minimum ASHP, CCHP, and HPWH. Item 5, appliance incentives should be available at the time and place of purchase if procured at a retail seller such as Home Depot or Lowe's. Item 6, ideally a significant majority of contractors that work in the company's service territory should be eligible to receive incentives. Item 7, planning and reporting of BE and DSM measures should always include the number of measures adopted, the appliance being replaced if that applies, utility cost of each measure, adopted, the projected energy and emissions savings of each measure adopted, the utilized cost of energy and emissions savings, and the total measures adopted as a % of the applicable total market activity in the company's service territory as reasonably determined. Item 8, because the company is likely to receive, for the time being, different inducements from implementation of BE and DSM programs via the strategic issues and clean heat proceedings, it should clearly track the expenditure of funds and which budgets they fall under. Expenditures should not receive both inducements, such as a PIM and amortization, wherein the company would be earning interest, available through those proceedings, respectively. Item number 9, strategic issues and clean heat plan funds should be spent in the following order. 1, strategic issues funds as specifically approved under the commission's decisions in the strategic issues proceeding. Decision number C23-0413 arising out of that proceeding before the inclusion of flexibility budgets. 2, clean heat funds as specifically approved under the clean heat proceeding decision before inclusion of the flexibility budgets. 3, the flexibility budgets approved in the clean heat proceeding. 4, the flexibility budgets approved in the strategic issues proceeding. Item number 10, flexibility funding should produce proportional energy savings and or emission reductions on a unitized basis as primary funding for all sources unless the company can explain the necessity to change the unit values embedded in the improved primary funding levels. Item 11, assess the split incentives issue to determine the number of income qualified and disproportionately impacted customers separately that own their home versus rent, and whether landlords are properly incented to invest in beneficial electrification and DSM measures in these communities. And if possible, the parties should work to meaningfully develop a tariff on bill financing program or something similar, and other tools to solve for split incentives. Item 12, acquire cost information of measures installed from participating contractors as well as square footage and age of home. Measure capacity, for example, cooling in tons, installation location, and other data to support refinement of incentives without being a burden to contractor participation. Item 13, program implementation should allow and leverage third-party implementation entities where reasonably possible to expand customer and contractor awareness of and participation in DSM and BE programs. Third-party implementers may be paid for signing up eligible contractors and customers. Item 14, Cost recovery, including a reasonable company inducement, should be aligned across funds from both the SI and SI being strategic issues and clean heat plan applications over the next 12 to 18 months. Essentially, the company should be provided a consistent and clear financial signal to run the programs effectively and efficiently with an appropriate level of collaboration and oversight from stakeholders and parties. And then finally, item 15, ideally, cost effectiveness evaluations should be aligned across funds initiated from both the strategic issue and clean heat proceeding applications over the next 12 to 18 months. Commission is planning to open a miscellaneous rulemaking docket to assess options and approaches given statutory requirements and pros and cons of alternatives to various testing and evaluation approaches. There's a very long list of items. And I know that if there are parties who are not included in the clean heat proceeding, this could be for some of you the first time you've heard this. So I know that my initial questions are not easy for everybody to answer. Just do your best. I've heard from the company and from staff. Let's hear from the UCA.
Thank you, Your Honor. Thank you for reading that list. I think that putting that in the record shows how overlapping that the clean heat proceeding and this proceeding is. And we were just thinking about that on Friday when we were discussing your proposal relating to an extension of the deadline for the decision in this proceeding, how voluminous the record was. Actually, UCA supports the extension and understands all the reasoning behind the need for an extension with the record the way that it is. And obviously, we would like the ALJ and the commission to have sufficient time to be able to review the record and come up with a decision that it feels comfortable with, that it had enough time. As far as the specific question of whether the commission's 15 points from the clean heat plan should be addressed in this proceeding, I think some of the issues have been addressed by the testimony, the written testimony that's been presented in this case, but certainly not all of the issues and certainly not in the detail that was presented by the commission on Friday. So it seems to me that from a practical perspective, Your Honor, would the timing of the decision in that case, right now it's set for May 28th, I think. And then briefing in this case, the SOP is currently set for June 14th. So when we were discussing that internally last week, we were thinking that we would have some amount of time to incorporate the clean heat plan decision into the SOP. But as far as your decision making, it seems to me that once there is a clean heat plan decision and it impacts the DSM process as much as those 15 points do, that you would feel compelled to include a discussion of those points. And so the UCA would support, I don't know what the proper process would be at this point, but the UCA would support including as much of discussion by the parties on the clean heat plan points in the briefing in this proceeding to aid Your Honor in considering those issues. I know as staff has raised the point of double counting and some of the reporting issues that were already raised, in our minds on how this was all going to be coordinated. And the UCA supports staff's issues and staff's proposals on that are in the record here relating to how to coordinate the clean heat plan. UCA really didn't have much in its testimony on the coordination of that. So I apologize, I don't really have a solution, but that is UCA's input, and UCA would support any kind of attempted resolution of those issues and does not agree that we should be ignoring the fact that the commission has issued such specific direction in the clean heat plan on how to coordinate the two sets of programs.
Okay, thank you. And just to, get this in the record early here, I did issue decision number R240323-I last week, essentially providing the parties notice that I want to hear from the parties this coming Wednesday. Just wanted to give the parties a little bit of time to think about the issues I raised in that decision, about whether, extraordinary conditions exist justifying extending the statutory deadline by 30 days. So my decision also notes that unless the parties have reached an agreement on that before Wednesday, we'll just address it on Wednesday. And I will say that then the commission added these 15 points on Friday, even after I issued my decision. It was already going to be a difficult situation in terms of getting a decision, frankly, that addresses all of the issues. When you're looking at a plan itself that's over 600 pages long, and then you've got 16 parties commenting on that 600-page long plan, it certainly does mean a very voluminous, a pretty big decision is what I would anticipate, especially where we have zero agreement. So I will say, more concerned now than I was when I issued that decision about the statutory deadline and the timelines that we're under. And at the same time, I recognize completely and understand party concerns about what a delay means, in terms of getting these products and these programs out, and how that delay can impact emission reduction goals. I'm with everybody on that. I understand all those concerns. I share those concerns. I also am concerned that what issuing a decision in the timeline may not be actually physically possible. Again, we don't need to address that now. I can ask the parties when we're done going through this list whether you've all reached an agreement, but I highly doubt you all have had the time to do that yet. Ms. Singer Nelson, you did raise one other problem that I see, and I don't really have a solution for it as of yet. I've been mulling it over, but yeah, I would have a very hard time ignoring what the commission has done in another case that is directly relevant to our case. I also believe it is really important to give everybody due process. I think that is pretty significant, and it's a significant part of my job as the judge in this case, to make sure everybody has a fair opportunity to be heard. Since the commission hasn't issued a written decision, I could not, after the evidence is closed, I can't just take administrative notice of the commission's decision, whether it be a final decision or not. I cannot do that without reopening the evidentiary record and then allowing the parties an opportunity to submit any evidence that the parties may wish to submit on the commission's decision in that case. And I certainly want to hear from the parties on how we might be able to do that. Again, not knowing when a final decision might come out. I know that there will be one, I think somebody noted May 28th. But that's a pretty big concern for me as well. And I don't even know if extending the statutory deadline will address that. So I'm just putting that out there. If anybody has any solutions, I would love to hear it. I'm still planning to proceed with this hearing. So please don't take any of this as me prejudging, hey, we can't go to hearing this week. That's still my plan unless the parties come to me with something else. So with that, I think Ms. King has raised a hand. Ms. King, go ahead.
Thank you, Your Honor. And I'd like to start by just saying thank you for appreciating the complexity of this overlap and giving that due consideration before we get going here today. While this might be unpopular, I think that this falls in the category of measure twice, cut once, and that there may be a more efficient way to proceed. Indeed, much of CEC's cross-examination planned for public service companies' witnesses today concerns the items contemplated by Commission guidance numbers 1, 9, and 10. And it may be significantly shortcut or if not eliminated as rendered moot by whatever the ultimate decision might be in clean heat on those issues. And so I recognize May 28th might be the day for a final commission decision. I expect that given the complexity of the issues presented in clean heat, there may be RRR that comes from that. And so it may be a month beyond that, at least, before we really know which direction we're going and what the marching orders from the commission are. At that time, I would think that we would be able to much more efficiently proceed with the elements of the company's DSM and BE plans that are presented for your consideration here. And so would present as one possible solution that we press pause on this proceeding until we know what's to happen there. I recognize that may not be popular, particularly on the part of many who want to see these efforts, don't want to lose time in that. And CEC shares in that sensitivity as well. We certainly would not be opposed to a continuation of the 2023 plan so that there's not a delay. And if there are, certain proposed modifications of can we get going on these particular elements of the 2024 through 2026 plan, possibly through the 60-day notice on those elements, we certainly would be open to that so that we don't lose the benefit of time, but that we do proceed in a way that's very efficient. This hearing is scheduled for 5 days. I don't expect, based on the cross-examination that's been anticipated, that we will need that, but certainly might be a more efficient use of everybody's resources here today if we know what the marching orders are and can honor that. So thank you for considering CEC's position on that. To one of the questions that you had posed of whether this might be an opportunity for the parties to get together and try to craft a solution together to leverage the guidance from CHP. While I have great respect for and optimism about all the parties participating here today, because we were unable to reach a comprehensive settlement, I expect that that would be a Herculean task for us to do. And so would respectfully request that we have more time and can craft that in a way that honors the other concerns of the parties. Thank you.
Well, Ms. King, I think you've put words a lot to a lot of things that I've been thinking. I think pressing pause and getting that decision would certainly make a big difference and be far more efficient for everybody. And frankly, I saw challenges to meeting the statutory deadline and getting things done quickly, even before that happened. And so we still may end up in a position where I make that determination that the deadline needs to be extended, regardless of what the parties agree to and say on this issue. So I am just putting that out for thought. Obviously, as I mentioned, I wasn't planning on addressing that issue until Wednesday, because I certainly wanted to give everybody an opportunity to really give that due consideration, considering that you were getting ready for this hearing at the same time. So when I call on everybody, if you all would like to just chime in on what Ms. King has proposed, I think that would also be helpful. Before I start going back down the list, let me just check back in with the company on that, because this is the company's application. And so I think the company's position on what Ms. King proposed would be pretty helpful for everybody to hear.
Thank you, Your Honor. Part of the difficulty of this discussion is it's not clear yet to the company what its position is going to be on these 15 items that you addressed, or whether any of those might go through, a further process of refinement. So there, I think Ms. King is correct that not only is there a risk of a slipped initial decision in clean heat, but there is also a risk of a further delay from where we get the real final decision. So in terms of addressing these issues and testimony in this proceeding, it does seem we would need to wait till there's real clarity on the final decision, which could take some time. And additionally, in terms of how we then incorporate these issues into the record, it does seem from the company's perspective that some testimony, whether live or pre-filed, would be helpful. I don't think it's enough for a statement of position to address the issues. I think there might be enough different positions of the party that some process of testimony is probably necessary. So putting that all together, the company does not necessarily oppose some additional process here, and the company's open to being flexible on time delays in order to ensure the record has the pieces Your Honor needs by all the different parties' positions to protect their due process rights on these fundamental issues. So, maybe one process is that the company goes back and coordinates with the parties on, maybe making a filing recommendation of what this looks like. I think the company might need a little bit of time of talking this through internally, and parties may want to do so themselves, and then have us coordinate to try to make a comprehensive and unified position to Your Honor on what the additional process looks like. Of course, if Your Honor wants to make a decision today, that's also fine. But it's a little bit tricky just given how uncertain things are.
I understand. We're all and the company probably hasn't had the opportunity to have very many internal discussions since this all just happened on Friday. So I get that. And I think this is one of those situations where you just never know what a judge is going to throw at you when you have a hearing set. And so I know I've thrown a pretty big curveball at everyone, and I am sorry for that. But I just think it's better to address the elephant in the room rather than have this hearing and then end up having to come back and redo a lot of the same work everybody is going to be doing throughout the course of this hearing. So, Mr. Manschultz, let me see if I can narrow down a little bit more to the extent you're able, the company's position in terms of do we move forward with our evidentiary hearing this week and then come back maybe after the commission has issued, at least a written decision, whether, I don't know if there's going to be triple R, we probably would want to wait for a final decision. Do we move forward now, or do we go ahead and hit a pause, get those decisions, set a process wherein the parties can submit written testimony, and then we can have a hearing that addresses everything all at once? I don't know what you were contemplating, but those are the two options I'm seeing.
If Your Honor, just give me 30 seconds to
Sure. And we can take a recess if I'm happy to even take 30 minutes, 45 minutes. We'll take a recess if that is going to get us better results in this discussion. We can certainly do that. Would that be helpful?
It would be. I know Mr. Dusky has his hand raised as well.
Okay. Well, let me just hear from them, and then maybe we'll take a recess. Mr. Detsky?
Thank you, Your Honor. Interesting discussion. I want, at the risk of sounding Donald Rumsfeldian, I would say that at some point, you have to go to court with the case you have. And from EEBC's perspective, first, we're not a party to the clean heat plan. And the industry is constantly in a position of having to juggle the cost and expense of litigating a proceeding like this and being in it versus what we've usually done, as you recognize, which is have a settlement. So it's unique for us to be going to hearing on this, but then the idea of further rounds of testimony, open-ended process could really put a strong burden on parties' resources who are not the company or the government. Let's say that there is a delay, or let's say that there is a delay here, and you have a decision comes out, a written decision comes out June 1, just for the sake of argument. That puts the RRR process into August or beyond before a final decision. The commission's already talked about that unlike this case, there is no CHP plan that's waiting on the shelf to be implemented. Once the company gets that decision in, then they go back to they start the drawing board to the extent maybe they have something going already. We don't know. Certainly there's been nothing public on that front. So then begins the process of compliance filings, stakeholder processes, maybe at least one miscellaneous docket Your Honor mentioned. I don't think that there's a time when during the period that's relevant to this docket that we're going to be at a place where the company has said, and the commission, that the CHP docket has been finalized, the company has gone through the compliance process, and the company now has a plan for how it's going to roll out whatever products and services that happen under the CHP context and how those may or may not affect this plan, which by then, in a hopeful world, could have been in effect for 6 months or more. So from the industry's perspective, it's not just that you'll be pressing pause here. It's more that we'd be in this kind of spinning circle loop until we figure out what, if anything, is going to come out of the CHP that would affect what we've done here. The CHP has a lot of funding in place. It has BE components. It has gas DSM components potentially, but none of those are fleshed out in any way. In fact, the commission has said that all we're doing here is setting kind of generalities. So we do have a very complex docket, and I very much understand Your Honor's frustration and the amount of material, technical, detailed material that will be coming before you, that it doesn't have the context that we usually do of a settlement agreement. But I don't think this is respectfully a measure twice, cut once job, because we don't even know what we're building. And so what would be, I think, more from the industry's perspective, letting this plan go forward and implementing it with the potential that down the road in a year, in 6 months now, there may be sufficiently developed CHP that requires an amendment of this decision or even a new proceeding that's done that would have the effect of amending this plan that's in fact going to be in effect for 3 years. I think that kind of process, in other words, going forward, what we have now may be superior than to just hitting pause and letting all this stuff that is really very ethereal right now form something concrete that can have a direct impact. And so while I do understand that this is out there like a big gorilla, that's a big cloud hanging over this proceeding and the outcome, on the one hand, I totally agree that that's true. They're completely overlapped issues. But on the other hand, I think it's worth it to recognize that one thing is formed and ready to go, and one thing is not. And from the industry's perspective, where the 23 plan doesn't have a BE plan, it doesn't have the decisions from the strategic issue decision that affect what we're doing now and the improvements that are in this plan. So from the industry's perspective, there are a number of reasons to go forward. And the things like aligning contractor support, getting contractor buy-in, that's right into EEBC's bailiwick, and we're fully in support of those things. We don't think they're going to be left to the wayside because we don't have a CHP in place. Those are normally part of the DSM process. And I think all parties are incentivized to harmonize those as you go forward. What really matters for whether or not we go forward right now or whether we press pause is, what are we pressing pause for? And if it's not something that will congeal in any timeline that any of us can be certain of, then I think it makes sense that even though there is this uncertainty out there, to move forward with what we have now. Thank you.
Thank you, Mr. Detsky. I will say that I think it really shouldn't be in question that the clean heat plan is definitely going to rely on and refer to program details that are going to be decided in this case. There's definitely a very strong connection between the two cases. And one of the concerns that I have is that if we just don't even try to address anything here, we can litigate, you guys can litigate this, spend all your resources, I write a decision, and then the commission completely turns things around on appeal because we didn't address what the commission asked the parties to address. So that is, one of the reasons why I brought up this issue is to try to make it so that when we get a decision in this case, it's one that can be relied upon. It's one where the record was developed well enough for the commission, not to send it back, frankly. And don't get me wrong, I really, really don't like the idea of a larger record than what we already have. That is the last thing I would really like to see happen, but it may, I'm just trying to figure out if, I don't know that there's much else that I can do other than have a better record than what we're probably going to have based on our current situation. So thank you for that. Let me go to a couple other folks who have raised a hand and then we'll take a recess. Mr. Smith with staff.
Thank you, Your Honor. First, I was part of my suggestion was a brief recess to allow the parties to sort of confer about what we've talked about here. I think that I just want to say on from staff's perspective, we recognize the importance of getting it right, and I think that that's one of the concerns that we have with. I think we share your concern with where the record is at now based on the clean heat plan discussion, given how intricately these two proceedings are tied together. I know that Ms. King alluded to CEC's cross was on several of those recommendations. I will be frank that staff's planned cross for today was almost exclusively on those recommendations. So to that end, I worry that if we proceed forward with those specific issues today, we may end up either being duplicative, which is inefficient, or we may end up in a situation where we end up with two different recommendations or two different records here, and I think that is also inefficient. So I would just suggest that maybe we can take a brief recess. I think there could also be value in if we were to have a little more time in this proceeding. Perhaps it would incentivize all of the parties here to come back to the table and look into potentially resolving some of these issues, at least some of these issues, and maybe reducing the amount of record. So I think there is value in that.
Yes, and Mr. Smith, to be honest, that was also my hope. All right, let's hear from CEO.
Thank you so much, Your Honor. And I do apologize. I also support on behalf of CEO a brief recess, but wanted to make sure we spoke to some of the points that have been raised already. CEO understands that this is at the ALJ's discretion. However, CEO has some concerns with delaying a decision in this proceeding. And CEO appreciates the complexity between the two records here. CEO was a party to the Clean Heat Plan and is very closely tracking the deliberations that are ongoing. In fact, CEO has raised this in its testimony in both proceedings regarding this complexity, and along with other parties provided guidance for how to reconcile the decisions in these proceedings. CEO supports the reconciliation process that the company has alluded to and is in their rebuttal testimony at this point in time. And CEO understands the company's proposal and the commission's guidance to both rely on final decisions in both proceedings. In particular, while there are still a number of decision points in this proceeding for Your Honor to rule on, the topics involving the greatest level of uncertainty involve the company's clean heat plan and its relationship to the final decisions in the most recent DSM strategic issues. For the record, 23A 03A-0389EG, got that number. While settlement may have been helpful with this matter, both proceedings have been fully litigated, both proceedings being Clean Heat Plan and the DSM Strategic Issues Plan. And while CEO would fully participate in any additional stakeholder processes, if that is directed by Your Honor, CEO has concerns about relying on further negotiations, considering the parties have not been able to resolve these matters through settlement in either proceeding. Finally, and I'm sure parties here and Your Honor are aware of this proceeding is a cornerstone for decision-making in the Clean Heat proceeding. In the deliberations, the commissioners have expressed excitement / concern over when is this going to be resolved so we can understand how this interacts. And for example, measures and rebates in this proceeding will be scaffolded on through Clean Heat. Additionally, a filing deadline for on-bill financing, which has been at the top of the commissioners' minds as well, is contingent on a final decision in this proceeding. So just wanted to flag our concerns at this point in time, and we thank you for your consideration and for this discussion.
All right, thank you. I thought Mr. Ragonen with sleep had raised a hand, but I don't see that anymore. I'll give him a second if he wanted to do that again.
Yeah, I can just quickly bring up a quick point, Your Honor. I just saw a no pop up on my Zoom, and I wasn't sure if that was directed at me or not. So Sweep just wanted to, while it is concerned about delay of statutory deadline, would also just raise potential option to have additional discussions to potentially resolve non-Clean Heat Plan related issues in this proceeding this week. I just think that there could be an ability for us to think about during this break, some sort of process for parties to come back together and at least resolve some of the issues to lighten the burden of the multitude of issues in this case.
All right, thank you. All right, well, we're going to take a recess. I'm not sure how much time would be helpful. Mr. Schultz, what do you think you need?
I might advocate for a longer one till 10:30.
Okay, that's fine. I know that I've brought up some complicated issues and there's probably internal discussions that need to take place. We will go ahead and be in recess until 10:30. If we come back and parties want a little bit more time, we can certainly do that. I just want to remind you all, we're going to continue to webcast during the recess. That includes the video and audio, so make sure that you are muted if you don't want your conversations webcast. You know what, before we take our recess, I remembered we didn't get an entry of appearance from the city of Boulder, and because Boulder was not here when I started this hearing. So let's get that entry of appearance. I think we do have somebody with the city of Boulder.
Apologies, Your Honor. This is Veronique Van Giem with the city of Boulder. I was here, but I was having some technical difficulties. So thank you for coming back to me.
Okay, great. All right. And then I think Denver has something to raise before we take our recess.
Yes, Your Honor. Sorry, not to prolong the discussion. I just wanted to make sure as we take the recess and I converse with my clients, is there a specific kind of menu of options that you want us to come back and kind of have a position on? Because I think there's been a few different ideas thrown out. And so I want to make sure I'm having a targeted discussion with clients as to what our position should be on certain ideas.
Yeah, I'll go back to the issues that I raised when I first kind of started this conversation, and that was just wanting to get a sense from the parties as to whether, and if so, how these guidance items from the Clean Heat proceeding that I went through could be incorporated and addressed in our case. So I think, and then also whether, what's happened in that case might be leverage for the parties to reach some agreements to minimize at least some of the disputed issues in our case, and particularly if there was more time to do so. And then I think sort of a separate potential question would be, I guess it ties into how we can incorporate that guidance, is how from a process perspective, if we all agree that guidance should be incorporated, what does that look like? Does that look like hitting pause on this proceeding until we have something more definitive from the commission? Does that look like proceeding with the hearing for the next 5 days and then coming back when we have more information. I could take administrative notice, for example, of whatever the final decision is, and then invite the parties to, either provide written testimony or hold an additional hearing. Again, I'm not saying I have any preference regarding any of this, and I'm not even sure how feasible it is for us to really do what I think the commission probably would really want us to do, which is to try to incorporate all of this. Just considering where we are with timing. And frankly, I say all that even with a potential 130-day extension of the statutory deadline. That I think that there are still challenges, even if that's the route that I end up taking in this case. So hopefully that lays it out for everybody. So it's now 10:05. I want to give you all at least a full 30 minutes. So we will we'll be in recess until 10:35. All right, before we go back on the record, let me just check in with my court reporter. Tracy, are you there and you ready?
I'm here and I'm ready.
All right, we'll go back on the record. I want to still give everybody an opportunity, if you would like, to address the items that I brought up. But let me just kind of go back to the company to see if you've got anything more to share on these issues based on your time, your little recess.
Thank you, Your Honor. The break was beneficial to the company in getting our position more solidified. And we do have two recommendations, which are alternatives. Our primary recommendation is multifaceted, so I'll go ahead and just lay it out. And for awareness, the company has not had time to collaborate with parties on this proposal. So unfortunately, we don't know their response to this. But the primary recommendation involves postponing this week's scheduled evidentiary hearing. We would recommend putting this case in abeyance, pending a final commission decision in clean heat. We understand that final commission decision in clean heat could very likely still be several months out. Approximately 30 days, give or take, from a final commission decision in clean heat. We would recommend scheduling an evidentiary hearing. At that hearing, to the extent items were not resolved through continued settlement discussions, parties could undertake live direct testimony on the more limited clean heat guidance issues. And all parties would have that live direct testimony option supporting their due process rights. And parties could, of course, conduct cross-examination of any non-settled item. During the period of abeyance, the company would recommend no additional discovery rights of parties to support the company's own due process rights. The company would, as I've been hinting at during this period, re-explore settlement opportunity with parties without giving any confidential discussions had by the parties. The company would note that generally the uncertainty caused by the clean heat case, in the company's perspective, made settlement somewhat difficult. With resolution of the clean heat proceeding, those items may be removed, opening doors to settlement potential. During the period of abeyance, the company would retain its rights to make 60, 90-day notice filings and take other actions outside of this proceeding that concern clean heat program changes. That's more of a clean heat based issue, but just for transparency and awareness, there may be need for the company to get things in market during this period of abeyance from clean heat. Overall, this recommendation would seek to ensure the company's will seek to ensure that the commission's clean heat guidance items through a final decision are considered in this DSM proceeding. It would expand additional settlement options, and it would promote the due process rights of all the parties. So that's our primary recommendation. I'm happy to address some thoughts on it, or I'm also happy to address our second option.
I do have a question for you before you get to your second option. I'm unaware of any statutory authority for the commission to put a case in abeyance. We've got either we can extend a statutory deadline for a final decision when there are extraordinary circumstances by an additional 130 days, or we do a waiver of the statutory deadline. And if there was a waiver of the statutory deadline, then I think we could put the case into abeyance because it wouldn't be on a strict timeline at that point. And I understand the phraseology of putting it in abeyance because at this point we don't know exactly when the final decision in the other case will come out. Most, I think, realistically, maybe later in the year, not a final decision in the next couple of weeks. So I'm just wondering, Mr. Minschultz, would the company be contemplating waiving the statutory deadlines so that I could put the case in abeyance under your first proposal?
I had not had opportunity to discuss that issue with the client. I'm happy to have that discussion, probably do so offline here now while this debate is going on. But I'll take that feedback to the client to understand positions. I don't know if we have a strict position yet of the best way of handling this period of uncertainty. Our recommendation of abeyance was essentially recognizing that the case would be at a standstill.
Okay, yeah, and I can understand that. It's just putting the case at a standstill while the clock is ticking on a statutory deadline really creates probably even more problems for me and for the commission. So why don't you give that some thought? Why don't you go ahead and give me your sort of alternative proposal?
Yeah, the second proposal, I'd say it's more along the lines of what Mr. Desky was putting forth. And it essentially would be, we're all here, we're all prepared for hearing. We would conduct the hearing as scheduled currently. We would generally not allow cross-examination on commission deliberation items in clean heat that are not yet finalized or in writing or based on an actual final decision. But also at the same time, reflecting that there could be these guidance items to incorporate into DSM. At the conclusion of this DSM proceeding, the company would go through additional processes to integrate those additional guidance items, which could take the form depending on the issue, because the issues are unique and specific to each of the 15 items through potentially company discretion, 60, 90-day notice issues, or an updated and amended DSM plan as each individual item may require. So that process would essentially, the pros there would be we would continue as we're scheduled today. We would make progress given we're all here, but there would have to be a further consideration of processes outside this proceeding to address potentially the guidance issues from clean heat.
Sorry, I had not unmuted myself. Thank you for that. While I hear from the other parties, if you could look into this question that I raised in terms of your first proposal and whether the company would contemplate a waiver of the statutory deadline so that the first proposal, I mean, without that, I don't know, the first proposal we couldn't do. We might be able to get some time if I find extraordinary conditions exist, but it's not going to be putting the case in abeyance because I'd still have to move the case forward. It couldn't be just put the case in a standstill while we wait. So why don't you?
I can respond to that now.
Okay.
Thank you for the long question, because we were able to confer, and under that scenario, the company would be willing to waive the statutory deadline.
Okay. All right. Thank you. And so I want to hear from the parties both on what the company has laid out and also on any of the other I mentioned issues that I have already raised before we took our recess. So I'll also let you all know, preview for you, that I think the first proposal to me, I think is the preferable one because it opens the opportunity for the parties to sit down and re-explore settlement. And in a case like this, a settlement generally seems to be best for everybody. Not to say that I'm afraid to decide the issues. If you all can't settle, if you can't settle, I'll decide the issues. But we do want to encourage settlement as well. As I'm sure you're aware that's the commission's policy. So I'll just say my preference would be for that first proposal. So with that in mind, let's hear from the other parties. I'll start with staff.
Thank you, Your Honor. Recognizing that we're all kind of coming up with it on the fly here, I do appreciate the company coming forward with what seems at first glance to be relatively reasonable options. A couple of things. The first option, I think, staff generally doesn't necessarily have an issue with what the company has suggested. I think the one concern we have is regarding what Mr. Manschultz alluded to regarding the 60-90-day notice process. And I apologize, I wasn't quite clear whether he was insinuating that the 60-90-day process might be used for clean heat plan or would be used here. And I think that sort of changes what I'm going to say next based on that. And Mr. Manschultz, are you able to clarify?
Yeah, let's get that clarified. I'll just say I didn't understand that to be in our case. I understood that to be in clean heat. Mr. Manschultz, is that correct?
Yeah, that's generally in response to clean heat issues, and that, there's a lot of overlap between clean heat and this DSM plan case and how programs operate in DSM. So I just want to be as clear as I can be that the company has obligations to reduce emissions to comply with clean heat obligations. And so if we get a final decision in clean heat, the company is going to be incentivized to get its clean heat programs in market to assist its ability to reduce emissions as soon as possible. And the mechanism at first blush to do so could involve 60 or 90-day notice filings to get program changes in market for clean heat purposes. And just given all the overlap here, try to be transparent on that front.
Okay, thank you. So, Mr. Smith?
So I think that kind of answers the question that we had regarding, I think one of the issues is that in the clean heat plan proceeding, staff has requested that the commission authorize staff to, in response to a 60-90-day notice process filing, to file a notice of deficiency if that what is proposed is not agreeable and contest that essentially. The understanding here is that in DSM, that right by staff has not necessarily been recognized. So that would be staff's concern if it was raised here. I think that we also, the concern with raising the 60-90-day process in the DSM is that staff would prefer that there be limitations on what may be introduced via 60-day notice while the case is in abeyance. But that's only if that's being used for this proceeding. So that's staff's concern here, is that if the 60-90-day notice process is used, staff doesn't have an ability to respond to that. We just want to make sure that there's not going to be additional programs that extend the budget or do various things via the 60-90-day process while we're still waiting on this case. Otherwise, I think that the other parameters that Mr. Manschultz laid out, no additional discovery, re-exploring settlement, those things I think staff can agree to. So with that, I think and then just as far as option 2, staff is prepared to move forward on the case now. I have some concerns with the suggestion that cross would be limited, I guess, or that parties would be unable to conduct cross on certain issues. I don't think that would necessarily be appropriate unless we were going to say that we're going to move those issues to even later in the week. So if we were going to move certain witnesses on topics to later in the week, I think we would be agreeable to that. But I don't think we can agree to just forego our right to cross witnesses here. And I think that we would just prefer to see an explicit confirmation from the company that there would be some limitations on what would be done through a 60-day notice while the case is in abeyance.
Can I just get you to maybe restate or clearly state what limitations you're seeking?
Staff would prefer that the 60-90-day process not be used in this proceeding to introduce new programs or to introduce new items that would expand the DM budget. So I think if it's done through clean heat plan, that's in clean heat plan. I view that as staff has already asked for its right to file a notice of deficiency. Here, because staff, that right has not been recognized by the commission in DSM, staff would like either the ability to do that or some explicit confirmation from the company that the 60, 90-day process isn't going to be used in that way.
I'm going to put the company back on the spot, mostly because I have a sense that the other parties would be asking a similar question, so we might as well get it out there. And I'll just say I don't see how the company could use a 60, 90-day process to impact the issues in our case, since we don't have a decision yet. And that process I've never seen that be used before there's actually marching orders from the commission. So, but Mr. Manschultz, could you just respond to that?
Yeah, happy to, Your Honor. For clarity, you can't use a 60-day or 90-day notice process to extend or grow your budget. It's for program changes. And what I'm referring to is about making program changes to implement clean heat issues. And to the extent the commission in its final decision changes the 60, 90-day notice processes for clean heat, of course, the company will comply. So whether it's staff's requested clean heat for changed processes, et cetera, we will comply with that. So with that, I'm not sure if there's any remaining concerns.
Okay, thank you. Mr. Smith, does that address the issues that you've raised?
I believe so, Your Honor. I think we're kind of rolling this around now, and I do understand that and I apologize to both you, the parties, and the company here for maybe muddling the issue. I just wanted to make sure it's clear. I think if you want to go around to some of the other parties and get some more feedback, I'd like to just kind of have a moment to kind of speak with my client.
Okay, thanks. I see that CEOs use the raise a hand feature, and I'll just let everybody know I am going to call on everybody. So unless you have something that you think would be a good thing to raise early so everybody can address it, then don't use that. And I see she's nodding her head. So go ahead and unmute yourself and let us know from CEO's perspective what it is that you wanted to share.
Sure. Thank you so much, Your Honor. And you hit the nail on the head. We wanted to bring something up for the other parties to comment on early, which is why I raised my hand during that discussion between staff and the company. So CEO sees merit in the proposals that have been presented thus far, particularly in sweeps and the EBC's proposal. We see we have a chicken and egg scenario here. We heard Your Honor express some need for clarity based on clean heat plan discussions and decisions, but we also heard the commission express some need for a written decision in this proceeding first. So CEO believes that some topics can proceed in this proceeding, which would assist in this reconciliation. From a topics perspective, CEO believes this to include the programs, products, and measures to achieve the DSM and BE goals determined in the strategic issues proceeding, and how the budgets determined in that proceeding are expended. So what we propose for parties' consideration and Your Honor's consideration is to hold a pre-hearing conference at around 3 p.m. today to determine what topics that solely relate to the record in this proceeding can be addressed in a hearing this week, beginning on Tuesday or Wednesday. So for instance, all of CEO's cross-examination to date relates to this proceeding directly. CEO would also recommend an additional pre-hearing conference later this week to identify what topics are at hand in both this proceeding and the clean heat plan proceeding. Parties would then provide guidance for a process to resolve this reconciliation. And finally, CEO believes it would be appropriate at that time to identify what topics cannot be addressed by either this proceeding or the clean heat plan proceeding. For example, some topics may have to be addressed in the company's next strategic issues filing, or may require modifications of the previous strategic issues decision. But just for the record, CEO would also be comfortable moving forward with either proposal from the company at this time. So we just wanted to put that proposal out there for the parties and Your Honor's consideration early on in this discussion. Thank you so much.
Well, while I have you, can you give me your position on the two proposals the company laid out? I mean, I know you've essentially outlined different approach, and I'll just say, there are a lot of topics. I mean, just the idea of the parties having to try to sit down and figure out what can and can't be addressed in a day, I think might be pretty challenging. I'm not saying that that wasn't a great creative idea. I just don't know how realistic it's going to be with the volume of issues. And I would be concerned with deciding up front what we can and can't hear about in the hearing, especially when we have a lot of things that sort of interconnect with each other. So I'm not really inclined to limit, once we go to hearing, I'm not really inclined to limit what we can and can't address. And that just ends up doing things piecemeal and potentially, I think, causing a little bit more confusion. But again, I'll hear from the, if the parties have a position on that approach, I would certainly like to hear it. But why don't you give me CEO's position on the two proposals the company laid out?
Sure. So as I noted, but I could put a finer point on it, Your Honor, CEO would be comfortable moving forward with either proposal from the company, be it the waiver of the decision deadline and the abeyance as described, or the second option. We still prefer our creative option, but just wanted to flag we would be okay. We can be flexible as needed.
Okay, thank you. Let's hear from the UCA.
Thank you, Your Honor. First, I guess as we consider, as the UCA considers all the options, including the one that was just presented by CEO, I think we're thinking about efficiency being directly impacting ratepayer interests and costs. So from that perspective, we would say that we would not agree with the proposal that was just presented to come up with a list of issues that are not impacted by clean heat and moving forward with a hearing on those topics. I think that would add layers of inefficiency to this proceeding that would end up costing ratepayers more money, at least in rate case expenses. And I don't have anything other specific types of expenses that would be impacted, but that's something to consider. But as far as the company's proposals, I think UCA's offline discussions were just very much in line with the first recommendation. So UCA would support the company's first proposal to put this proceeding in abeyance, give the parties time to talk, see if there are any issues that can be resolved based on the clean heat plan decision, and then have a hearing and additional testimony later. I did have a question as to why live direct would need to be presented. I was thinking that perhaps what the parties could do would be to have simultaneous written direct on how the clean heat plan issues can be addressed, and then that would give parties more time and Your Honor more time to consider the various positions before we actually go to hearing. So then we could do cross based on written direct. That would be one of my suggestions. And then with the clarification, I think that the company provided earlier relating to the 60-90-day notice period being limited to clean heat plan programs and clean heat plan issues. That clarification helped a lot. So so in summary, UCA supports the company's proposal, the option one with a suggestion that we have written simultaneous testimony relating to the clean heat plan instead of live. Thank you.
All right, thank you. Let's hear from Boulder.
Thank you, Your Honor. Boulder respectfully disagrees with the company's proposals. We are open to CEO's proposal, noting that we were very close to settlement on most issues other than a few that were explicitly connected to an absence of the decision in the CHP. We believe that we can narrow down the focus of this proceeding to things that would meaningfully move the proceeding forward. We also agree with EEBC and Mr. Detsky on his description of losing ground in the DSM for what is likely to be a year of CHP resolution. This proceeding already has guardrails set through the statute and the strategic issues proceeding, so Boulder believes this evidentiary hearing should go forward. We would like to acknowledge that the targets and budget requirements set through strategic issues sets more aggressive requirements for the company than it would have to achieve its performance incentive mechanisms as compared to just extending the 2023 plan. So our recommendation would be that the hearing should be suspended for a day or two and require parties to try to reach partial settlement on some issues. And for those issues that are not resolved, Your Honor could have the parties provide recommendations on how to proceed with the balance of the hearing. Boulder wouldn't object to a short delay for Your Honor to have more time to review the record, but with regard to the issues that overlap with the CHP, we agreed that alignment of the program design is important, but did not hear anything that should materially alter the course of this DSM proceeding. And so Boulder recommends that Your Honor could set a filing compliance requirement in this plan that would address how the company intends to resolve those issues once the final decision is reached in the CHP.
So are you saying you think it's realistic that the parties could reach a partial settlement in a few days? Because I got to tell you, I've not heard anybody else really say that's a realistic possibility.
We think that the company made a good faith effort to reach settlement, and the issues could be narrowed to ones that do not extend to overlap with the CHP.
Okay, that's different than what you said a moment ago, because you were talking about settlement. Moving this.
Well, they could be narrowed through settlement, we believe.
Okay, all right, thank you. Let's hear from WRA.
Thank you, Judge Mirbaba. It feels as though we're at a buffet with options that all are not particularly appetizing, but we'll endeavor to identify for WRA which of the routes presented, which to my understanding are now 4. I think for WRA, one of our key concerns animating our thinking around how this case proceeds is having the DSM BE plan implemented in a timely fashion. And there are pitfalls and advantages of each of the options from that lens. I also have concerns about any delay to implementation of clean heat and how delay of a DSM BE plan decision might compound delay in that proceeding. With that throat clearing out of the way, I think of the 2 options presented by the company, WRA has a slight preference for the former. We also see some merit to CO's proposal, and there may be, without getting into confidential settlement discussions, I think that the way that issues are often segmented in a settlement discussion makes it easier to identify those issues when we go into some sort of pre-hearing conference setting to identify what could be or what could not be addressed at this hearing. Though I think, as Your Honor noted, there are a lot of contested issues remaining in this proceeding, and so it may be difficult in a pre-hearing conference with less than a day's notice to fully make that delineation. And on the final proposal that Boulder's attorney just put forward, reacting in real time, I think it's an interesting idea of trying to narrow the issues for this hearing. I don't know that we have a position on that either way.
Okay, so I think I heard you say that you have WRA has a slight preference for the company's first proposal, but honestly, I'm not sure I got that down correct. So I just want to clarify. That's
correct.
And then, so that would be ranked over in order of the three proposals, where does that fall? Your first preference?
That would be our first preference of the three proposals. I also understand that other parties may be presenting new proposals after WRA has weighed in on what is currently on the table, and so would just acknowledge that we may also like to raise our hand as new variations of what's currently presented arise.
Okay, thank you. I'll finish going through hearing from everybody, and maybe there's a chance at the end of that, what I might actually end up doing is saying we're going to recess for the rest of the day and let all of you talk to each other a little bit more. And then I can also take that time to think about everything everybody is throwing out in terms of these approaches. So I'll just preview that for you all. I know that you're all having to sort of be very nimble today. And I know that can be a bit challenging when it's hard to connect with your clients. So that is a potential option for later. So let's turn to the Conservation Coalition.
Thank you, Your Honor. Before I say our preference between the two options that Mr. Mansholt outlined, I'll say that we would strongly advise, if Your Honor is seriously considering delaying the proceeding, the option one, that I think it'd be very useful for there to be a filing prior to Wednesday's deliberation in clean heat that alerts the commission to that possibility and allows them to consider it in their clean heat plan deliberation. And I say that because the commission has expressly been counting on implementing the clean heat plan through this DSM and BE plan for the second half of this year. And that's baked into the things that they have previously decided in clean heat. And I don't think that their deliberations in clean heat have accounted for a possible delay of this plan, which would in turn, as various people have alluded to, delay implementation of clean heat. So we would strongly recommend if option one is on the table, that there be a filing today or early tomorrow morning so the commission can consider that at Wednesday's clean heat plan deliberations. With that, we would tend to prefer option two because, you know, this was supposed to be a 2024 DSM and BE plan. If it's paused the way I understand it to be, we likely wouldn't get a decision till the end of this year, and that would delay not only this plan, but it would delay implementation of the clean heat plan, which we don't think would be helpful for either proceedings.
Okay, thank you. Let's hear from Sweet.
Thank you, Your Honor. I think first, Sweep agrees with what Boulder raised in terms of potentially being able to, and hopefully being cautiously optimistic here, reach settlement on certain issues in the near term. And I think given the two options provided by the company, Sweep would prefer option two. However, if we do go with option one, Sweep would just raise that, you know, we would want a deadline in the near term, specifically around settlement issues. And we'd also be wanting a commitment to work towards settlement on issues that don't impact clean heat. And this is just as a result of all the reasons that other parties have provided in regards to waiting to approve this 2024 DSM plan until next year, potentially, and just overall concerns about implementing these new changes in the near term.
All right, thank you. Let's hear from Denver.
Thank you, Your Honor. It sounds like we're doing a bit of ranked choice voting, so I've been conversing with my clients on the fly here. I think, from the options that we have right now, our first preference would be option number one as presented by the company. I do agree with UCA's suggestion that in lieu of kind of live direct testimony, that it be pre-filed direct testimony. I think that would probably expedite things at the ultimate hearing that we go to and just make for a cleaner record. But so I guess option one with that slight modification. And we would support Mr. Gerhardt's suggestion of filing some sort of notice to the commission prior to Wednesday, just if we are going down that route. As to, I guess, kind of our second choice in ranked voting, CEO's suggestion as to if we could kind of parse out issues that could move forward and those that cannot would be kind of our second choice. And then third, I guess, is the company's option two.
Okay, thank you. I think I've already heard from CEO, so let's hear from EOC.
Thank you, Your Honor. So I think, primary to EOC's considerations here are impact of delay to vulnerable income qualified customers if programs are not put in place. And some of those changes that are in the record in this case are not contested. For example, IQ prescriptive rebates. No party has contested that those should go forward. So I'm having a little bit of trouble in terms of option one, which is keep everything in abeyance, which my understanding means that the 2023 plan just continues as it is now. Initially, Ms. King suggested that there could be a process by which some changes to the 2023 plan went into effect while all this was sorted out. Staff, I heard say they don't want any changes to the 2023 plan as this is getting sorted out. So I would just put in the mix that that seems, if Your Honor is inclined to proceed with option number one, that it doesn't make sense to limit the ability to put in place through the 60-day notice or through just a decision here, certain changes to the plan that no party contests. And so that if we did go forward with the hearing, Your Honor would have that record before her. So I'm struggling with that chicken and egg as well. I do, Mr. Gerhardt's suggestion about filing something with the commission seems appropriate. I also heard Your Honor say that one of your concerns is going forward with a procedure in this case and having the commission come back and say, no, that's not what we wanted. So it seems to make sense to me to put it before the commission, either what they would like or at least raise what Your Honor is moving forward with here and see if they have any objections, so that we don't face that same issue you were concerned about. So it's kind of hard to state in a clear way what our preference is. I think if you're inclined to go with a stay, I think there shouldn't be limitations on how the 2023 plan could be modified through some kind of process.
So can you just tell me what does EOC have a preference on the three options? Like third option, the one that CEO proposed, second option, or the first option with the caveats that you've given? I'm not really sure.
I think CO's alternative of seeing if there are issues that can be decided would address my concerns that there are parts of this plan that can and should go forward without the CHP interplay. So I think our preference would be for number 3.
Okay, all right, thank you. Mr. Smith, did you have something more you wanted to add before I continue to hear from the rest of the parties?
Yes, Your Honor, and I just wanted to clarify for EOC and Ms. Stockmeyer. I just wanted to. I think it might have not have come through. Like staff, we're not saying that we don't want any changes made to the 60-day notice process. We're saying that we just want there to be limitations, and specifically that we don't want the 60-day notice process to be used as a mechanism by which things that are still being litigated here can be sort of tacked on to the DSM plan through that process. That's all we're saying. We're not saying we're opposed to any usage of the 60-day notice process. That's all I wanted to clarify. I also I will say that I think we've heard now twice that about doing written versus live direct, and staff we didn't offer an opinion on that. We would prefer live direct. We think the record's already voluminous. To add more through written testimony, more written testimony about items that, frankly, I think we've all written about in some way, or most of us have written about in some way. I don't know that would be particularly useful as opposed to just doing a live direct. So I'll just throw that out there. But I appreciate the time.
All right, thank you. Let's hear from EEBC.
Thank you, Your Honor. I think that the salient point that rings true from what you've heard from SWEEP, from EOC, from CEO, is that there's a lot of issues in the plan, a lot of proposals that are not contested. That we do have a very voluminous record. And EEBC, were we to litigate, would be litigating on aspects of our very detailed proposals that were not accepted by the company in rebuttal. But between the company's acceptance and rebuttal and the parties' positions in the case, there are many issues, including the ones that EOC raised, that are not contested. And a lot of those, I think, are sort of caught in the crossfire here, especially because a lot of those don't even have anything to do with clean heat plant. Maybe they're on electric efficiency, or maybe they're on demand response. And it would be a shame from EEBC's perspective to have those proposals just sort of caught in the delay that would happen in the company's proposal number 1, where the case is just paused. And then I heard Mr. Smith say that they don't want changes coming into the 23 plan that are part of this plan. So for example, if there was an IQ provision that was unopposed in this plan and the parties agreed it should happen, then maybe staff opposes that coming in through a process that would have the effect of changing something that's in the 23 plan. That, I mean, is a very Rube Goldberg type process that we're working on here to get that done. And I appreciate the position that Your Honor is in to try and parse through all this. What we were trying to figure out was, is there a way that we can move forward, continue settlement discussions, and maybe even reach a partial settlement that gets us off the dime on a lot of these uncontested proposals in the 24 plan and has those go into effect. But then reserves for hearing the effect of the CHP decision when and if it comes out finally on what has been put into effect, perhaps even, and I'm just completely off the top of my head here, on an interim basis, pending a final resolution of the matter later on. And so that's what we're struggling with is there's a lot of good policies and proposals, very technical, very specific proposals that we want to see go forward and that are uncontested. From EEBC's perspective, there is a subset of contested technical proposals that we could litigate were the company's option 2 to proceed. Even those, I would argue, are not CHP plan dependent. The CHP is, if anything, mostly a bolstering of what we decide here as opposed to a disapproval of the things in the plan. And I guess so of the 3 choices that you have, I think everything I've just said fits mostly more closely into the CO proposal, even though that I am sort of amending it to say, is there a way that we can let the plan get implemented with those proposals that are uncontested, whether or not that's through a hearing this week or through a pre-hearing conference where the parties are allowed to go back and talk and see if we can come up with a proposal that allows that to happen, rather than litigating it this week. These are all very complicated decisions, but I think that there's a bit of conflation going on in terms of what is actually in the CHP in that decision that's going to bear on the technical proposals that are in the 600 pages of the DSM plan, not necessarily the PIMS or the CHP related policy matters or that stakeholder processes that would result once that pot of funding is released. But really the nitty gritty nuts and bolts that are largely uncontested and we hope could be finally resolved in a partial settlement, if the parties were allowed to have a mechanism for that to go forward. So maybe that's a little bit long-winded and circuitous, but it's getting late.
Okay, all right, thank you. Let me hear from Claire.
Thank you, Your Honor. Clear generally does not have a strong preference as between the options on the table. I will note we have a very narrow set of issues compared to most parties in this proceeding that are generally not impacted by the CHP plan. And so we would be amenable either to proceeding with the company's option 1, so long as there is adequate room and direction to really encourage a settlement opportunity, or CEO's option, which would allow a bifurcation of the issues to proceed, but no strong preference between them. Thank you.
All right, thank you. Let's hear from Climax.
Thank you, Your Honor. Oh, here we go. There we go. There I am. Very interesting discussion. We are on the periphery of the primary, or I shouldn't say primary. Many of the issues in this case are concerned is primarily budget and PIMS. I have a couple of ideas in light of that. And the first one is recognizing that it appears that a number of the, as Mr. Detsky put it, the nuts and bolts issues are uncontested, that there be a process, 1, to identify the uncontested issues, and 2, to attempt a settlement on a partial settlement on those, with encouragement of that from Your Honor. I don't think you can resolve those without there being some agreement among the parties. But the idea would be then to bifurcate those issues from the all others. The identified resolved issues through an encouraged partial settlement process. And then I think as to the rest, I think our preference would be for public services proposal number 1, because I do think that the interaction between the CHP and the issues of concern to us in this case is important to know before they're resolved in this case. Now, that does create a dilemma, I believe, because I'm not quite this idea of a filing before Wednesday to advise the commission that there is under consideration some sort of delay, whether it's abeyance, waiver of the statutory deadline, or whatever it might be. I don't know how the commission deals with that. And I don't know how you and the parties in this case would deal with however the commission does deal with that. We could all listen to the discussion about that, which would be on short notice, at least on Wednesday. But at most, we'd get a wink and a nod, and not a decision that, yeah, it's okay, or no, it's not, or it's okay under these conditions, or what. So I'm not quite sure. I do like the idea of the commission being notified. I think that's important, but I don't know how they or we and you would know what to do with that. Other than notice, I don't know how we do that. So my suggestion, our preference would be public services number 1 with the interim encouragement of partial settlement to resolve the either uncontested or largely uncontested or resolvable, maybe I should say, issues in a settlement, and with a quick deadline, say Friday, and then bifurcate those issues and proceed with the deferral or abeyance with the waiver of the statutory deadline as to the remaining issues.
All right, thank you. Let's hear from CEC.
Thank you, Your Honor. CEC supports Public Service Company option number 1. CEC appreciates many of the comments presented by parties about the interest in potential partial settlement. While the interplay of the 2 proceedings, the DSM BE plan on the one hand and the Clean Heat plan on the other, while that's admittedly complex, I don't think Your Honor's order procedurally needs to be so, and would recommend that if we pursue option number 1, that there be established a settlement deadline. And I don't think it needs to be early. It can be a month from now. It can be 2 months from now, but it's up to the parties to work in good faith as their interests appear towards settlement. And then the remaining parties, whether they're party to that settlement or not, can consider whether they support, oppose, or take no position. And then it's up to Your Honor to decide that. And so certainly there may be motivation on the part of some to act early, but that may not be shared by everybody. And so I think it's up to the parties to act in their client's best interest and to go from there. Nothing precludes a party from submitting a settlement earlier than the deadline, and nothing limits that there only be 1 partial settlement presented to Your Honor for consideration. And so that would be CEC's recommendation of how best to proceed procedurally. We have significant concerns about parsing what issues are severable from CHP, particularly if the budget and use and prioritization of the budget is what ties them. And so it's very difficult to think through accepting we're going to proceed forward with certain programs or initiatives without knowing how those are going to be paid for. And so we would have a difficult time at a pre-hearing conference being able to parse those out. And so just to summarize, we support option number 1 and appreciate Your Honor's careful consideration of all these issues today.
All right, and finally, Iconergy.
Thank you, Your Honor. Iconergy supports the company's first proposal and would just echo the comments of Ms. King and Mr. Fanyo. I do think it would be hard for the company to figure out what to do with potentially settled issues without a budget in this case. I agree with Ms. King. Parties are always free to file a settlement agreement, and Your Honor would have the procedural flexibility to then hold a hearing on that settlement while we wait for a clean heat decision and figure out how to handle that in the context of this case. But proposal number 1 is the cleanest option. Thank you.
Okay, I think you all give me a lot to consider. At this time, what I would like to do is take a recess to consider everything on the table. Before I do that, I just want to go back to the company to see if the company has anything more to add for consideration, just in light of all the positions that the parties have taken.
Thank you, Your Honor. No change to our proposal number 1 that we've heard not every party agrees with, but the consensus of parties appear to agree with. I would just note though on like a settlement deadline for different comments there, I would just be a little bit cautious in setting a settlement deadline too early, because the clean heat deliberations that are still ongoing may cause additional confusion or otherwise that may have an impact on settlement. As I hinted at earlier, I think some of the issues of a lack of settlement include the uncertainties from clean heat. So I would not want to necessarily have some deadline that's too early before we have got some clear guidance of a very minimum, an initial decision from clean heat. So just food for thought on that issue there.
Okay, and while I got you, I think it was EOC that made the comment or the suggestion that there are, a number of programs that are uncontested, and, maybe we could possibly allow those programs to get implemented while everything else is being resolved. And I'm just wondering what your thoughts might be on that.
Yeah, my thought is that those issues roll into our some discussions, which allow parties like staff who may have concerns about 60-day or 90-day notice changes could offer their thoughts and positions. So by having those discussions in a unified and comprehensive format, all parties have the ability to raise concerns, and there's not concerns. Presumably, settlement of those issues would be possible, with implementation as maybe something for parties to consider that they may be agreeable to in settlement prior to a full decision in this case. In other words, there's an opportunity for parties, say an IQ program change. Parties could potentially settle that program change should go into effect in June. And that could be a term of the settlement. And to the extent a party disagreed with that implementation date, they could raise those concerns in the settlement process.
Okay, but as to the suggestion essentially that uncontested issues or programs or products could be implemented while the contested issues are still pending, is it your position that we could do that through the 60-90-day process?
Yeah, again, I think generally that is possible. So you could have a settlement that lays out certain programs being implemented at certain dates while others don't. There's a lot of flexibility in settlement. I think the total flexibility provided by that process could address all party concerns.
Okay, so but what I'm hearing is that we would want that if we are going to go down that route, a settlement needs to be finalized, at least for what we know as we sit here today is undisputed or uncontested issues. Is that right?
I would agree that to the extent parties have concerns on extending this proceeding, and those concerns could be mitigated through settlement of non-contested issues, that then yes, there would need to be a settlement on those non-contested issues.
Okay, thank you. So it's about,
Your Honor.
Yes.
Apologies. I just wanted to echo. I would agree with Mr. Mansholt completely on the points he just made. To the extent that there are these uncontroverted technical issues, I think the process that we're talking about would afford them the opportunity to bring those in an uncontested partial settlement on those issues. But I would agree wholeheartedly with Mr. Mansholt on that.
Sure. And honestly, given the volume of our record, I would want to see, a single document that lays out, what everybody has agreed is uncontested and can be put in place. Otherwise, trying to piece that together with the volume of documents in our case would be a very challenging task, I think, especially if we're looking at doing something quickly. So thank you for that. I think I've got a lot to think about here, and I will also just note that generally, I haven't taken off the table moving forward with our evidentiary hearing, but just will note that I don't think we're in a particular time crunch. I think, even with what we've done today and this delay that we're having right now, if we proceed, we will, I think, still have time to be able to get this done this week. And then also I'll let you all know that if necessary, one of the things that I will be thinking about when we take our break is potentially delaying even just for a short period, even to next week. I'm going to give that some thought because that I think is a little bit more consistent with what CEO had recommended. So I will give that some thought as well. It is about 11:40 right now. I think what makes the most sense is for us just to take a lunch recess a little bit early, unless there are any other issues that we need to talk about before we take that recess. We can recess until 1 o'clock, and it'll give all of you a little bit more time to connect with each other and with your clients. I'm going to consider everything everybody has laid out, and we'll be prepared when we come back at 1 o'clock to address how we're going to proceed. And then if you guys have an agreement you're able to reach over the break, which I understand is probably not likely, I would also hear that at that time as well. So before we take that recess, is there anything else that anybody would like to raise? All right. Oh, Mr. Valentine.
Yeah, just one thing, Your Honor. I am not totally clear on the current 2023 plan. I assume that's what we're operating under now, and I just assume that would continue on until this case is resolved. And I would like to hear a little bit from the company about their thoughts on continuation of the 2023 plan. Obviously not now. Thanks.
Well, and I'll say that I have a note here. I believe that was part of the proposal that the company laid out. That was sort of that first proposal. Mr. Mansholt, did I get that correct? That the 2023 plan would continue essentially if we go with the first proposal that would hold this case in abeyance?
Yes.
Okay, that's what I thought. All right. Mr. Valentine, does that address your question?
Yep, thank you.
Okay. All right, then we will be in recess until 1 o'clock. And again, I want to thank you all for being nimble with me here today and responding to all of these wrenches I've been throwing at you. I appreciate it. And I know that you are not in an easy position. I have a lot of sympathy for all of you. And I am sorry that I had to do it, but I just didn't feel like I had much of a choice. So again, we will be in recess until 1 o'clock, and I'll remind you the webcast is going to continue to stream. So if you stay on, go ahead, make sure you mute yourself. Thank you. Good afternoon. Before I go back on the record, let me just check in with my court reporter to make
I'm
sure.
ready.
All right, thank you. We'll go back on the record in proceeding number 23A-0589EG. So I will just kind of go over what my thinking is as of now based upon the discussion that we had this morning. So while I appreciate the company's efforts to come up with an approach that would allow the parties to incorporate the commission's guidance from the Clean Heat Plan proceeding after that guidance is memorialized in a final decision, I also share many of the parties' concerns with a significant delay that would result with putting this proceeding into abeyance, particularly given that there appear to be some issues that the parties could agree upon or that are otherwise unaffected by the Clean Heat Plan proceeding. So I'll just say at this point, I'm not inclined to go with that option, the option of holding the case in abeyance until a final decision is issued in the Clean Heat Plan proceeding. So assuming that there's going to be a need to move forward with an evidentiary hearing, what I'm inclined to do is to direct the parties to simply do your best throughout the course of our hearing to try to address the guidelines that the commission provided in the Clean Heat Plan proceeding, with, of course, the understanding that the commission has not issued a final decision on that, and frankly, that the parties' positions on that may change later down the line, depending on what the commission's final decision is. This, I think, is most definitely far from ideal, but ultimately, at this point, I think it's probably the lesser of evils compared to a significant delay in this proceeding. So with that in mind, I do have a couple of other ideas that I'd like to pursue, and that would be, for one, I'd like to give the parties the next few days to come together to discuss whether you can resolve any of the issues in this case and reach a settlement, even if it is only partial. This would also allow the parties to discuss together approaches to potentially incorporate the guidance from the Clean Heat Plan case before we go to a hearing. I don't want to do a significant delay, so what I am thinking is that we would vacate the next couple of days of hearing and come back to hearing on this Friday, May 17th at 9 a.m. We are already scheduled for hearing on that date, and I can check in with the parties and see where they are with settlement discussions and negotiations. If at that time there is really no hope to reach even a partial settlement, then I would say let's go ahead and start the evidentiary hearing on Friday. If the parties believe that with a little more time they can reach a settlement, even if only partial, then we can schedule the hearing to take place pretty quickly, possibly sometime the following week or the week after, just depending on where the parties are with a potential settlement and how much time the parties might need to do that. And I would not anticipate written settlement testimony. I would anticipate that if we go down this route, that those agreeing to the settlement agreement could testify to it if that even is necessary. Also, I just want to let everybody know I'm really not inclined to bifurcate issues, which would essentially mean allowing the parties to come back at a later date after we've done an evidentiary hearing and present evidence on other issues. And that includes bifurcating for the purpose of allowing parties to bring in more evidence to address issues arising from the decision, the final decision in the Clean Heat proceeding. The timing of how these proceedings have moved is very unfortunate. It presents a lot of complications that we talked about at length this morning. But my concern is that bifurcating will just add even more layers of complications, and that'll just escalate even further if we do that. Any agreement that the parties may be able to reach will impact a determination on whether extraordinary circumstances exist to justify an extension of the statutory deadline. And so for that reason, I really want to get a sense from the parties about settlement prospects, before making a determination on that question. So when we convene on Friday, I can at that time figure out whether I can decide that issue at that point, or if I have to decide it later, depending on where things are with settlement. And frankly, if there is a settlement, I would also want to know how many issues are we going to have left that are contested. That would also impact a determination on whether extraordinary circumstances exist. That's where I'm at right now. I guess what I'll do is just check in. I'll start with the company. Do you understand what the plan is? Do you have any response, any concerns? Essentially, we would be vacating the hearing except for the rest of the afternoon. Tomorrow, Wednesday and Thursday, reconvening at Friday morning at 9 a.m.
No questions, Your Honor, on your decision points here. And we probably don't need to make a decision now from when a full evidentiary hearing may be held. But as we continue to work into next week and others, we get closer to that initial clean heat plan, potential date of the initial decision. So something to keep in mind as we schedule that hearing. But otherwise, understand the decision points. Thank you.
Okay, great. Yeah, and along those lines, if we are getting really close to at least something getting issued in that case in writing, we can certainly plan around that. That would most likely also influence, when my determination on whether extraordinary circumstances exist as well. A week or two might still mean that I need more time to get a decision issued, even if we narrow issues. Again, I'm not deciding that right now. That'll be something that gets decided once I have a better sense of settlement as well. So let me just check in with the other parties to see if anybody has any questions about this, or if there's anything you want to raise. I see Ms. King. A couple of people have used the raise the hand feature. Let's start with Ms. King with CEC.
Thank you very much, Your Honor. I do have a question with respect to your intentions. I heard you say that you're not keen to have a bifurcation of issues. What I would request clarification on is how are some of the issues that are squarely at issue in the commission's deliberations on clean heat and anticipated to come from that decision? How would Your Honor appreciate those being handled in the context of this proceeding, namely use of budget flexibility, for example, which is one of the decision points at issue in the commission's deliberations?
Sure, and I think that, in that 15-point list I gave you all this morning, that was one of the items for sure. And I also think, at least I could say that some parties may have already presented their position on that. So really the thing that I'm hoping for is for the parties just to do your best based on when we go to hearing, what has been decided in that case, to do your best to try to address it. If you agree with what the commission has laid out and you have your client has a specific approach for it, great. I'm going to set my expectations low. I'm not going to assume everybody is going to be able to do the type of comprehensive work you would ordinarily do if you had that in writing and you had a lot of time. So all I can say is I'm just going to ask the parties to do what is reasonable in light of the circumstances when we come to the evidentiary hearing date. And I can't lay that out in detail right now because I don't exactly know when that'll be and if there is going to be a written decision that's already come out by that point. My plan here is to try to get this case moved forward without any kind of significant delay, with keeping in mind that I still may have to have some delay just given the circumstances that there may be extraordinary circumstances that require that. Does that make sense? And Ms. King, I know I may not have really thoroughly answered the question the way that you would have liked, but that's probably the best I could do for you.
I appreciate it. Thank you so much.
Okay. All right. Thank you. And Ms. Nelson for the UCA.
Yes, Your Honor. I could be the only one that's confused about this, so I apologize if I'm wasting anybody's time. But again, you said you're not inclined to bifurcate issues. having a later hearing on some issues, let's say the parties are able to reach settlement on a subset of issues, then are you willing to have a hearing on the issues that aren't settled? Is that what you have in mind?
If the parties are able to reach a settlement, even a partial settlement, let's say it's a partial settlement, not all the issues are decided. I'm kind of thinking that might be the best I can hope for in this case. So I'm sort of thinking that might be the path potentially that we'll see. What I would anticipate is coming to hearing as soon as we're able, after that settlement has been written up and filed, and holding a hearing on, to the extent necessary, the settlement agreement. There might be some questions that I might have about it. There might be parties that are opposed to it. And then also to address any remaining disputed issues at the same time. So we just do it all at once.
Thank you.
All right. Any other questions? Mr. Smith?
Yes, Your Honor, and I think I don't think we necessarily have any questions. I would just like to voice staff's preference, given, and I think I probably speak for a lot of parties here. If we could have the remainder of the hearing in May, that would be fantastic. I understand that we're under a pretty tight deadline here, but that would be very helpful just for scheduling purposes. But yeah, otherwise, I think that what you've proposed sounds reasonable.
Sure, and I'll let you all know, I was just looking at the calendar and, I think, again, depending on where things fall with settlement, that we could be back in hearing next week. I've got all day on the 21st open, the 23rd, I've got the 28th, the 30th, the 31st. If we needed to go in June, the first week of June would be out, but then the following week would be pretty open. And then I understand the concerns about delay, and that's really what I'm trying to avoid, but also trying to just see what we can do to address all the issues that have been discussed this morning. Mr. Faneuil, you've raised a hand. Is there something you want to raise?
Thank you, Your Honor. I'm uncertain about the process you have in mind if there's a partial settlement, and then you spoke about a hearing on the settlement with a determination of what issues remain. The point of a partial settlement would be to implement whatever those terms, particularly uncontested ones, could be implemented early. If there was not a final decision on the partial settlement, presumably that would be in limbo until the final decision in the entire case. And so I'm not quite, and yet you were not inclined to bifurcate. And so I'm wondering what you have in mind, if anything, and I guess I'm not asking for a ruling here, but to raise the question because it may have an impact on the discussions of the parties in how they come to a partial settlement if they can.
Well, I'll just say in my experience, there have maybe been 2-3 settlement agreements I've seen in all of my time at the commission that I didn't have questions about. So the chances of not needing to hear from the parties on it it might be kind of slim. It's always a possibility. So I'd probably still need to hold, a hearing. That's what I'm assuming. I sort of take your question as, could there be a decision approving a partial settlement quicker than a decision resolving all the potentially remaining disputed issues, so that settlement agreement provisions could be implemented, programs within there could be implemented quicker than having to wait on a decision on disputed issues. Is that what you're getting at?
Yes.
Okay. I'm not completely closed off to that idea, but it's not a question I can really answer unless I were to see what that settlement is, because what it's hard for me to say right now is whether there's going to be any interdependence between items in the settlement agreement and items that are still in dispute. I think I would also really need to do my own digging and research to determine procedurally whether there's a mechanism for that, because typically when I issue a recommended decision, I lose jurisdiction in a case. And in deciding a settlement, it's like a recommended decision. I don't know how to approve a settlement agreement without it being a recommended decision that's appealable. And so I do have a concern about doing that. That approach might affect appeal rights. And I'm just not sure that there is really a procedural mechanism to make that work. I don't know that I can't necessarily hold on to a case and continue to decide issues in a case. So that's a bit of a conundrum, and I appreciate where the parties are coming from. What I have tried to do is make it easier for everybody to reach an agreement and to move this case forward. And if there are partial agreements, I can tell you right now, that will shorten the amount of time I need to issue a recommended decision in the case. So I will encourage the parties, even if I cannot approve something to go into effect immediately, realize that any agreements that you reach will result in a quicker recommended decision across the board. So hopefully there's still that motivation to reach agreements.
That's helpful. Thank you.
Okay. All right. And then I think CEO, Ms. Clicchio, if you would like to let us know what you're thinking.
No, thank you so much, Your Honor. I appreciate the additional clarifications regarding the proposal that you've put forth for a solution and to continue settlement discussions. I just wanted to flag, given the hope for a short time frame to have a hearing on the settlement that hopefully comes to fruition, or a hearing period, for us to have a scheduling conversation as a group as soon as possible, given some planned days out for council and CEO staff next week. There's just some conflicts that are already coming to mind, and we just wanted to flag that as soon as possible.
Yeah, I would like to encourage the parties, when you're talking about settlement, to also just start talking about some dates. Obviously, we're going to reconvene on Friday, and so if we're going to set, different dates, I'll have everybody together at that time. But it's always helpful if parties have had a conversation, in advance about that. And I've already given you sort of a preview of some of the dates that will and will not work. The first week of June would be out, so just make a note of that when you guys are discussing.
Understood. Thank you so much, Your Honor.
Okay, again, thanks to everybody for all your efforts. And I wish that things could have been a little bit different, but it is what it is, and we're just going to do our best. Is there anything else that we should talk about before we adjourn? All right, I'm going to take silence to mean no, and I'm going to work on a written decision to memorialize this plan, and that would vacate the hearing for the rest of the afternoon, tomorrow, Wednesday, Thursday, but maintain the Friday hearing date at 9 a.m. And like I said, if there's no hope for settlement, we'll proceed. We'll at least do day one of the evidentiary hearing on Friday. Ms. Keene?
Actually, you just answered my question. I was just confirming if Friday was just to schedule a future hearing, or if we might proceed into hearing on Friday. And it sounds like it's the latter.
Yeah, and again, if there's no hope for any kind of settlement, we might as well take advantage of that day that everybody is going to be available.
Perfect. Thank you.
All right.
Your Honor, I'm sorry, this is a last minute thinking, but we don't have to do this now, but maybe we don't do it now, then maybe early Friday, if there are some witnesses that could be excused from an evidentiary hearing as not having time on the cross matrix, for a lot of different parties. So if we don't do it now, that's fine, but maybe it's something we should also thinking about for Friday, in terms of me just getting all my witnesses here on that date and for the other hearing dates as well.
Yeah, I think that makes sense. So if why don't you all talk to each other about that? I am going to take another look at this. I was just going to pull it up to see if I could figure it out right now, but I might need a little bit of time, because there's a chance there might be a couple of witnesses nobody else has questions for, but that I have questions for. But I'll be ready to address that on Friday and ask that the parties also be prepared for that.
Thank you, Your Honor.
All right. Thank you, everybody. We're going to adjourn, and I will see you Friday morning at 9 a.m.
Thank you.